Agnes Wren was 34 years old when her brother-in-law placed a key on the solicitor's table and told her that was all she was getting. The key was wrapped in a strip of brown cloth, the kind used for polishing boots, and it had been sitting in Robert Wren's coat pocket for 3 weeks, ever since the morning the judge had ruled in his favor, and Agnes had stood in the courtroom in Dorchester and listened to 6 years of marriage reduced to a procedural question about inheritance lines. Her husband Thomas had been dead for 41 days. He had left everything to her in writing: the house, the farmland, the cattle, the grain stores already laid in for winter, with a solicitor present and 2 witnesses, signed and sealed in the proper manner. None of it had been enough. The original Wren family settlement, drafted in 1801 before Thomas was born, bound the property to the male line in the absence of male issue. Robert's lawyer had found it. Robert's lawyer had used it. And Agnes had walked out of that courtroom with 41 days of grief, a carpet bag containing her clothes and her father's survey casebooks, and the promise of a tidal mill on the estuary that no one had entered in 10 years. Robert had not looked at her when he set the key down on the solicitor's table. He straightened his coat and turned to speak to his solicitor as though the matter were entirely concluded. Agnes picked up the key. Beneath it, tucked into a fold of the cloth, was a small piece of paper in Thomas's handwriting. Not the formal, careful hand he used for the farm ledgers, but the looser, quicker hand of a private note. It said, "The deed box. Look at page 3. She folded the note and put both it and the key into her coat pocket. She had not known, until that moment, that Thomas had understood more about the mill than he had ever said aloud. Agnes had grown up in a household where water was a working matter rather than a natural feature. Her father, Edmund Carr, had spent 30 years as a drainage and water rights engineer in the coastal counties of southern England, a methodical, unhurried man who had spent his professional life reading rivers, negotiating tidal channels, designing sluice gates, and assessing the legal instruments that governed who was permitted to take water from where, and when, and in what quantities. He had no sons. From the age of 12, Agnes had sat beside him at the drawing table in the back room of their house in Bridport, copying survey plans onto clean paper when the originals grew too worn to read, filing the county water rights applications in their card envelopes, entering the annual license renewals in the household register. Her father had taught her to read these documents not as legal formalities, but as working plans, to look for the clause that carried the weight, to trace the chain of entitlement from one instrument to the next, to notice when a right had been allowed to lapse, and to understand what that lapsing meant in practice for the people downstream. He had also taught her that the most consequential line in any water rights document was rarely the one the parties argued about. It was the quiet line, the subordinate clause, the condition buried in the 3rd paragraph of the 3rd page that everyone initialed without reading all the way through. He had won 3 county disputes on the strength of such lines, and Agnes had copied the relevant paragraphs into her own notebooks each time, because he had told her that a clause you have written out by hand is a clause you will not forget. She had not forgotten any of them. She had carried those notebooks through her father's final illness, through the move to Thomas's farm, through 6 years of marriage and 1 gray morning in a Dorchester courtroom, and they were in her carpet bag when she walked into the solicitor's office and picked up the key. When Edmund Carr died in 1849, Agnes was 29 and had been managing his professional correspondence and filing for 7 years. She married Thomas Wren the following year. Thomas was a decent, careful man who farmed 200 acres on the coastal plain east of Bridport, and who had been, Agnes had long suspected, quietly relieved to find a wife who could manage the farm accounts without instruction. She managed them without difficulty. She had also managed the water intake licenses for the farm's 2 irrigation channels, renewing the permits each year at the county office, reading the renewal documents with the same attention her father had taught her, noting what had changed from the previous year's form, what language had been subtly amended, what a small addition to the standard wording might mean over time. It was ordinary, routine work. She had not imagined it would one day be the only useful knowledge she had left. She had not met Robert Wren until Thomas's funeral. He had come from Bristol, where he managed a modest importing concern, and he had been cordial at the wake and businesslike with the solicitor in the days that followed. Agnes had not understood, until the morning of the hearing in Dorchester, how completely and carefully he had prepared. The original Wren family settlement of 1801 had been drawn up when Thomas's grandfather consolidated 3 parcels of coastal farmland into a single holding. The document was plain on its central point. In the absence of male issue, the property reverted to the nearest male Wren relation. Thomas had left no sons. Robert was the nearest male relation. Thomas's will in Agnes's favor was a valid instrument, the judge explained in measured tones, but it could not override the terms of a settled estate that predated the marriage by half a century. The settlement took precedence. Agnes's solicitor, Mr. Phillips, had argued that the marriage contract conferred certain protections and that Thomas's explicit testamentary intention should carry weight in any equitable reading of the settlement's terms. The judge had considered the argument and disagreed. Robert's lawyer had come with 3 precedents from the past decade, each directly on point, cited with the calm confidence of a man who had prepared the ground carefully before arriving to stand on it. The hearing had occupied a single morning, and had been conducted with the brisk efficiency of a proceeding whose outcome Agnes suspected everyone in the room except her had anticipated before they sat down. She had listened to every word. She had not cried in that courtroom, which she considered afterward the only significant achievement of the day. Outside on the Dorchester street, Robert had paused and told her she could apply to the court for a maintenance allowance if she found herself in difficulty. He said it as though it were a generous offer rather than the minimum the law required of him. Agnes had thanked him with the same level voice she had used all morning, and had walked to the coaching inn and sat down and ordered tea she did not drink. She spent the first week afterward at Mrs. Ellen Paley's cottage, a widow of 60 who had been a neighbor of the farm for 20 years, and who offered Agnes the spare room without conditions or excessive expressions of sympathy. Ellen Paley brought tea and did not ask questions. Agnes was grateful for both in equal measure. On the 3rd night, she opened Thomas's deed box. It was a battered tin affair with a brass clasp, kept on the study shelf beside the farm ledgers. Thomas had managed the property documents himself, one of the few practical matters he had preferred to handle without consultation. Inside, beneath the deeds to the farmland and farm buildings, all of it now Robert's, Agnes found at the very bottom, wrapped in a sleeve of brown card, a folded document marked in Thomas's hand, Mill, Original Deed, 1791. She remembered the note from the key cloth. Page 3. She unfolded the document carefully on Mrs. Paley's kitchen table, smoothing the folds with both hands. It was 4 pages long, written in the close hand of a late 18th century legal copyist, in iron gall ink that had turned the color of dried rust. The first 2 pages described the mill's location on the estuary channel, its physical dimensions, and the terms of the original grant. The 3rd page carried a heading Agnes recognized from her father's filing system, which had used the same wording on county applications across 30 years, water rights and easements. She read the clause 3 times before she set the document down. Then she poured herself more tea and read it a 4th time, slowly, the way her father had taught her to read any clause that carried real weight. The mill stood at the edge of the estuary, where the tidal channel narrowed before opening toward the coast. Agnes walked there on a gray Thursday morning in November with the deed in her bag and the key still wrapped in its cloth in her coat pocket. The path was more overgrown than she had expected, not the casual untidiness of a track unused in winter, but the deliberate encroachment of years, bramble and seagrass closing in from both sides so that the stone footpath beneath was barely visible. A path that had not been maintained because no one had been meant to use it. The building was still standing. The walls were 2 feet thick, old coastal limestone put up to outlast the people who had built it, and the salt air had done less damage to the stone than to the timber elements. The door had warped badly in its frame and required her shoulder before it gave. Inside, the floor was under water, dark and still, approximately knee-deep, smelling of brine and old wood, and something underneath that, something older and mineral, the smell of a place that had been sealed from light and air for a long time. The ceiling beams were intact. The grinding shaft and gear assembly above were coated in a gray-green film of lichen and salt, but had not collapsed. The mill wheel was visible through the seaward opening, a large timber and iron structure, its paddles half-rotted and gray with age, held entirely immobile by a heavy iron bracket bolted across the axle. The bracket carried a lock, not a rusted, neglected lock, one that had been oiled, the metal dark and clean in a way that old iron left outdoors in sea air was not. Agnes crouched at the opening, with the cold water around her ankles, and looked at it for a considerable time. Then she straightened and turned, and looked at the channel. The tidal inlet ran along the mill's northern wall and continued inland, and Agnes could follow it with her eye for several hundred yards before it curved behind a low rise in the ground. It was clear. No weed, no debris. The stone banks intact and recently repointed, the water running freely between them. For a mill that had stood empty for 10 years, the channel that fed it was in remarkable working order. Someone had been tending it, not occasionally, in passing, but regularly, as part of an established routine of maintenance. The stone banks did not repoint themselves. Someone had come here, season after season, with mortar and tools, and had kept this channel clean and clear and flowing. Agnes stood in the empty doorway with water lapping at her boots and looked at the channel for a long time, following the line of it inland until it disappeared behind the rise. She went back that afternoon and walked around the mill's exterior before going inside again. The stone walls were sound on all 4 faces. The seaward side, where the wheel sat, showed the most weathering, salt pitting in the mortar joints, the wooden lintel above the wheel opening gray and checked with age. But the structure was not compromised. The millstone housing above was intact. Someone who knew what they were doing could put this building back into use. Agnes had no doubt about that. The question was what it was worth, and to whom, and on what legal basis. She stood at the seaward face and looked at the oiled lock on the wheel bracket one more time. Then she went to find Joseph Doyle. Doyle was the village blacksmith and millwright, a large, deliberate man in his late 50s who had maintained the mechanical works of mills across that part of Dorset for 3 decades and who spoke about machinery with the quiet authority of someone who had never needed to raise his voice to be believed. He had known Edmund Carr, which was recommendation enough on both sides. He listened to Agnes's description of the mill's condition without comment, and when she mentioned the lock on the wheel bracket, he set down the hinge he had been working on and asked if she was certain the lock had been oiled. She said she was certain. He was quiet for a moment. And the channel? Completely clear. The banks have been repointed within the past year, I would think. Possibly more recently. Doyle looked at the wall of his workshop, rather than at Agnes, in the way he had of thinking through a problem before speaking about it. "Someone has been using that water," he said finally. "Not the mill, the channel, drawing it off inland to the fields on the rise above the estuary road." Agnes had been considering exactly this since she left the mill. She asked which farm lay above the estuary channel on the inland side. Doyle said that would be Hatch, George Hatch, 300 acres of mixed pasture and arable, been working it for 15 years. "Good land, very well-watered land," Doyle added, and left the observation to stand without further elaboration, because he was a man who understood when a statement had said enough. Agnes returned to Mrs. Paley's kitchen and opened the deed to page 3. The water rights clause was 11 lines long and precise in the way that her father had always said the best clauses were: no room for argument about what the words meant, only about whether the facts matched them. The mill, positioned at the head of the tidal channel, held the primary easement over all water flowing through the channel between the estuary mouth and the upper boundary of the mill land. Any secondary use of that water, for irrigation, livestock watering, drainage management, or any other agricultural application, required the written agreement of the mill's owner, renewed annually, with a fee set at the mill owner's discretion. And then the condition: the primary easement was active and enforceable as long as the mill was in operational use. A mill with its wheel at a standstill was not, by the terms of the deed, operational. Agnes took the morning coach to Dorchester the following day and spent 2 hours in the county land registry. She asked the clerk for the water use filings for the Hatch holdings going back 15 years, and for the water rights renewal records for the mill. He found them without particular difficulty. A methodical young man who fetched what was requested and did not inquire into the reasons, which Agnes appreciated. She arranged the documents on the reading table in 2 separate groups, the way her father had taught her to organize competing sets of records before comparing them. One group for what should have been filed, one for what had actually been filed. Then she worked through them page by page, making notes in the small ledger she had brought with her, checking each entry against the next with the unhurried attention she had learned to give to documents that other people had not bothered to read carefully. There was no water use agreement for the estuary channel anywhere in the Hatch filings, not one, for any year across 15 years. The channel appeared in the Hatch boundary records only as a geographical marker, a line on the survey plan indicating where the Hatch land ended and the mill land began. There was no license for water abstraction, no application for easement rights, no record of any fee paid, no correspondence with any mill owner about permitted secondary use. Agnes then asked for the water rights renewal records for the mill itself. The last renewal was dated October 1848. After that, nothing. 13 years without a renewal. The rights had been allowed to lapse in the administrative record, which meant they still existed in the original deed but had not been maintained as active instruments. Which also meant that George Hatch had been drawing water from a channel to which he held no legal entitlement, and had been doing so, by Agnes's careful counting, for at least 9 years. She sat with her notes at the coaching inn before the return journey and thought about the oiled lock. A non-operational mill could not enforce secondary use restrictions. The deed was unambiguous. A mill with its wheel bolted in place was not operational. The lock had been fitted, recently enough to still be clean and functional, for the specific purpose of keeping the mill from running, the water rights from being enforceable, and the channel from being anyone's legal concern. It was a neat arrangement. It required only that the mill owner be unaware of it, or be kept away from the mill, or be given no reason to look at page 3 of a deed written 80 years before she was born. She asked Doyle the following morning to examine the lock and the bracket fitting and give his best estimate of when the ironwork had been installed. He went to the mill that afternoon and came back with his assessment. The bracket and fittings were consistent with foundry work from the late 1840s. A particular style of iron compound and bolt threading he associated with a Weymouth works that had operated until 1852. Agnes already knew what had happened in the late 1840s. That was the year Thomas's father had transferred the mill to Thomas. It was the last year the water rights had been renewed, and it was the year Robert Wren had last been recorded in the county, in the chapel register at Abbotsbury in September. She laid everything on Mrs. Paley's kitchen table in order: the deed, her registry notes, Doyle's assessment, the Hatch water use records, the register entry. Her father had taught her to build a water rights case the way he built a drainage plan, from the source outward, each channel traced before the next was drawn, nothing assumed that the survey did not confirm. The picture was complete, and it was clear. The original deed gave the mill owner primary rights over the estuary channel. Those rights were enforceable while the mill was operational. The lock had been fitted to render the mill non-operational and allow the water rights to appear dormant. Hatch had used the channel freely, year after year. The rights had not been extinguished, only suppressed. The deed was intact. Agnes owned the mill. The water rights were hers to revive if she could demonstrate operational function. She needed the wheel to turn. She went to Doyle with the deed and explained the situation plainly. He read the water rights clause carefully, asked 2 questions about the registry records, and set the document down. The bracket and lock would need to come off entirely, he said, and at least 2 paddle sections were too deteriorated to bear the channel flow without risk of the whole assembly breaking loose. New timber, new fittings, 4 days of work. His charge would be £5. Agnes had £2 and 9 shillings. She told Doyle she would have the full amount within the week, and asked if he would begin on that basis. He said he would not. He had worked on promises before, and the experience had not recommended itself. Agnes thanked him and returned to Mrs. Paley's. George Hatch arrived the following morning. He came to the cottage door with his hat in his hands and the carefully arranged expression of a man who wished to appear reasonable because he had recently been informed he had cause to be alarmed. Agnes knew before he opened his mouth that someone had told him she had been to the county registry. He said he hoped they could reach terms like practical people. He named a figure for the water rights: £40, paid once, no further obligation. Agnes's father had valued channel easements of equivalent scale at £12 to £15 per annum, across 9 years of uncompensated use that amounted to a very different sum. She said she would consider his offer and thanked him for calling. After he left, she explained everything to Mrs. Paley from the beginning, sitting at the kitchen table with the documents laid out between them. Ellen Paley listened without expression until Agnes had finished. Then she went to the bedroom and came back with a small tin and counted out £2 onto the table without comment. Agnes began to object. Mrs. Paley said that Edmund Carr had surveyed her drainage channel in the winter of 1846 and would not accept a penny for the work, and she had been looking for a suitable occasion to settle the matter ever since. Agnes accepted the money. She went to Doyle that afternoon with £4 and 2 shillings and told him she had the rest. He looked at the coins on his workbench and said he would start in the morning. He began at first light. Agnes worked alongside him when she could, not on the heavy ironwork, which required Doyle's skill and his tools, but on the timber elements, clearing accumulated salt and debris from the wheel housing, removing the worst paddle sections, preparing the intake gate for adjustment. Her father had explained the operating principles of mill gear systems to her on paper when she was 16, as part of a broader lesson about water-powered machinery. She had never repaired one, but she understood how the parts related to each other, which meant she could work usefully, without asking questions that would slow Doyle down, and in such circumstances, that was nearly as good as experience. On the second morning Hatch returned, this time with a letter from a solicitor in Dorchester. The letter stated that in the event the mill remained non-operational, his client would be filing an application to have the water easement formally extinguished as abandoned under the relevant county statute. Agnes had 7 days. She read the letter, noted the date, placed it beside the deed in her bag, and went back to the mill. On the third day, Agnes arrived at the mill before Doyle. The morning was cold and clear, the estuary flat and pale in the early light, the channel running quietly along the wall. She stood in the doorway for a moment, the water still around her ankles, the shaft above her still, the paddle housings smelling of fresh timber and salt, and she thought about her father walking this same kind of ground, the estuary path, the survey rod over his shoulder, the casebook open in his hands. He had surveyed 6 or 7 tidal mills over the years. He had always said they were the most honest kind of machinery, because they took nothing from the landscape that the landscape was not already offering, and they returned it downstream without complaint. On the third day the wheel turned. Not cleanly. It caught twice in the first rotation, and Doyle had to adjust the intake gate before the flow was sufficient to maintain the momentum. But it turned. The water entered from the channel, the paddles engaged, and the great shaft above them began to move with the slow, protesting reluctance of something that had been held still for a very long time, and was not yet certain it wished to move again. Agnes stood in water up to her ankles and watched the wheel complete its first full rotation. Then its second. By the fifth it was moving with something approaching regularity, the sound filling the old stone space above them, deliberate and unhurried and unmistakable. Doyle set down his tools and said, "There it is," and nothing further, because nothing further was required. She sent word to the county water inspector that afternoon. Mr. Gale arrived 2 days later, a methodical man in his 50s who had assessed waterworks across Dorset and Hampshire for 30 years, and brought with him a clipboard, a measuring rod, and the unhurried calm of a man who had seen every variation of the argument he was about to adjudicate, and had formed no particular attachment to any of them. Agnes met him at the mill door with the original deed, her registry notes, and Doyle standing to one side in his working coat. The wheel was turning. Gale walked the full length of the channel, examined the mechanism, read the water rights clause twice, and asked Agnes 3 questions. Was she the recorded owner of the mill? Was the deed she was presenting the original instrument? And had the wheel been in operational use when he arrived? Agnes answered yes to each. Gale made notes on his clipboard and said his written assessment would be issued within the week, but his preliminary finding was that the mill was operational, and the primary water rights attached to the original deed were accordingly active and enforceable. Agnes wrote to Mr. Phillips that evening, enclosing copies of the relevant documents and Gale's preliminary finding, and asked him to inform Hatch's solicitor that the easement extinguishment application had no basis in fact, and that Agnes intended to enforce the water rights as set out in the original deed, effective immediately. She spent the following days calculating the annual license fee. She used the rates her father had set in comparable cases, adjusted for the acreage irrigated from the channel, and arrived at a figure she was prepared to defend in any county office in the south of England. She called on the 2 smaller farms that also drew from the channel. Neither had sent lawyers, and both agreed to annual licenses when the situation was explained plainly. Hatch held out for 11 days. Then his solicitor wrote to say his client was prepared to negotiate. Agnes negotiated. She set the annual fee at the rate the easement warranted, no more and no less. Hatch signed the agreement and paid the first year's fee at the end of the month. By the following spring, the mill was in regular operation. Agnes had arranged with Doyle for the grinding mechanism to be fully restored, funded from the first year's license income, and had agreed terms with a grain merchant in the next village to process a portion of the coastal harvest on commission. The mill was not large, and it would not make her wealthy in any rapid or dramatic sense. But it worked, and it was hers, and the account book on her desk balanced at the end of each month with the quiet precision of a well-maintained drainage plan. Mrs. Paley's £2 had been returned within the month, with a small addition that Ellen had accepted in the spirit in which it was offered. Doyle had been paid in full. Mr. Phillips had received his fee and had written a brief, formal note of congratulation, which was the professional equivalent, Agnes suspected, of a considerable degree of surprise. Agnes had moved into the mill-keeper's cottage, a small stone room attached to the east wall, which had required only cleaning and one repaired shutter to become habitable. She had set it in order with the same methodical care she had applied to everything since November: the desk against the window that faced the channel, the shelves for the growing file of licenses and correspondence, the ledger open on the desk at the current month's page. She set Thomas's deed box on the shelf above the hearth. Beside it, she placed her father's survey casebooks. She had carried them in her carpet bag on the morning she left the farm, and had not put them down since, because they were the most useful things she owned, and she had understood that before she understood anything else about her situation. The channel ran outside the window. The wheel turned. Every morning when the light came in off the estuary, she could hear it, steady and unhurried, the sound of something doing exactly what it had been built to do, once the thing that had stopped it had been found and removed. The two smaller farms on the channel renewed their licenses without difficulty at the start of the new season. Hatch renewed his under the terms Agnes had set and did not correspond with her on any other matter. Mr. Phillips wrote to say the easement registration had been formally updated in the county record. Agnes filed the letter with the rest and updated the ledger. Robert Wren did not return to the county. Agnes heard through the ordinary channels of village life that he had sold 2 of the farm's outlying fields to settle a trading debt in Bristol, a merchant who had not extended patience beyond the agreed terms. She did not seek this information and felt no particular satisfaction when it reached her. She had not needed Robert to fail. She had needed only the deed and the wheel, and 4 days of work alongside a man who did not ask questions she could not answer. The water moved through the channel, as it had moved for 100 years before anyone thought to lock the wheel. The key sat on the shelf beside the deed box, still wrapped in its strip of brown cloth, because she had not thrown it away. It had opened the mill door on a cold Thursday morning in November, and done exactly what a key was meant to do. The ledger was balanced, the fire burned in a hearth Thomas had never seen, and the water of the estuary channel ran where it had always been meant to run, through the mill that had been waiting, with considerable patience, for someone to read the 3rd page of its deed. There is something in Agnes's story that stays with me long after the telling is done. She did not inherit money or influence or the goodwill of anyone who held power in that county. She inherited a locked wheel, a flooded floor, and a key wrapped in boot cloth. What she brought to it was not luck and not rescue. It was the specific knowledge of a woman who had spent years reading documents that most people set aside unfinished, who had learned from her father that the most important line in any contract is usually the one on the 3rd page, the one no one reads all the way through. That knowledge had no obvious value until the morning it was the only thing she had left, and then it was worth everything. If that kind of story finds you at the end of a long day, I would very much welcome you among the listeners here. There is a subscribe button nearby, and pressing it costs nothing, and means the next story will reach you without any searching required. And if you would like to leave a comment, I would be glad to hear this. What did you notice first? The clean channel or the oiled lock? Because Agnes noticed both at the same moment, and that is what made all the difference. Thank you for listening. I will see you in the next story.